Hi there, welcome to our YouTube channel where we talk about different estate planning topics in order to help all of you better understand estate planning. Today I want to talk to you about the Corporate Transparency Act update. I'm attorney Kelly Longtin from Kelly Longtin Law. We practice estate planning in Massachusetts and New Hampshire. Now, under the Corporate Transparency Act, so I'm going to call it CTA, just to shorten that up, that took effect in January 1st of this year, 2024. Many business entities, including small limited liability companies, or LLCs, and partnerships, are required to file reports with the Treasury Department's Financial Crime Enforcement Network, or FinCEN. In these filings, applicable businesses must disclose important information about their entity. However, recent developments have called into question the constitutionality of these requirements. So let's talk about what the Corporate Transparency Act is and what the requirements are. The CTA is a federal law that requires business entities, referred to as reporting companies, to disclose certain information about the company and its owners to FinCEN. Under the CTA, a reporting company is defined as a corporation, LLC, or similar entity that is created by filing a document with the Secretary of State or a similar office under the laws of a state or Indian tribe, or formed under the laws of a foreign country and registered to do business in the United States. The following information about reporting companies in the United States must be included in this report. You need the company's full legal name and any trade name or doing business as name, the street address of the principal place of business, jurisdiction where the business was formed, and the tax identification number. Additionally, the reporting company must provide the following information to FinCEN about its beneficial owners, and that's defined as persons who hold significant equity, so 25% or more ownership interest, in the reporting company, or who exercise substantial control over the reporting company. You need their full legal name, their date of birth, their current residential or business address, and a unique identification number from an acceptable identification document, like a license or a FinCEN identifier. For reporting companies created on or after January 1st of 2024, the same information must be provided about the company applicant, and that's the person that files the creation documents for that reporting entity. Now, there has been some current litigation over the Corporate Transparency Act. There's a case, National Small Business United versus Yellen, and that's in the U.S. District Court for the Northern District of Alabama. And it was ruled by the opinion that the CTA is unconstitutional because Congress lacks the authority to require companies to disclose personal stakeholder information to FinCEN. The National Small Business Association, an Ohio nonprofit organization representing more than 65,000 businesses from all 50 states, and Isaac Winkles, an NSBA member and owner of two small businesses, had brought suit against the U.S. Department of Treasury and Treasury Secretary Janet Yellen, alleging that the mandatory disclosure requirements imposed by the CTA exceeded Congress's authority under Article 1 of the U.S. Constitution and violated the First, Fourth, Fifth, Ninth, and 10th Amendments. The U.S. Department of Justice has since filed an appeal of the District Court's decision with the U.S. Court of Appeals for the 11th Circuit, asserting that the CTA is constitutional. And then we have Boyle v. Yellen. On March 15th of 2024, William Boyle initiated a lawsuit in the U.S. District Court for the District of Maine, alleging that the CTA is unconstitutional. The lawsuit states that Congress exceeded its authority under Article 1 of the Constitution and encroached upon the states' respective sovereignties in violation of the 9th and 10th Amendments and constitutional principles of federalism and retained state sovereignty. And there's yet another case pending, the Small Business Association of Michigan v. Yellen. On March 26th of 2024, the Small Business Association of Michigan, Chaldean American Chamber of Commerce, Stewart Media Group, LLC, Power Connections Company, LLC, Derek Dicko, Semper Real Estate Advisors, LLC, and Timothy A. Eisenbrun filed a complaint for declaratory judgment and injunctive relief alleging that Congress exceeded its constitutional authority. The CTA amounts to an unreasonable search and seizure, and the CTA is a violation of due process. In response, the U.S. Department of Justice has filed a brief asserting the constitutionality of the CTA. So what does this all mean, and where do we go from here? With one case decided and two awaiting further proceedings and other lawsuits being filed, there'll be little change for most business owners. The decision in Alabama only applies to those named plaintiffs. Anyone who is not part of that case is still required to comply with CTA requirements. We understand that the landscape is constantly evolving, and we're going to do our best to keep updated and to keep you updated so you could comply with any and all applicable laws. I want to thank you for watching. This is just more information about the Corporate Transparency Act. If you want to know more about estate planning, please like and subscribe our page below. Thank you for watching. I'm Kelly Longtin from Kelly Longtin Law.